Well, greetings again. Today I'm going to go through the subject matter of rules. This is probably the dullest, most uninteresting lesson in the entire series. It's got to be, because who in the world wants to listen to a bunch of dumb rules? But it's also geared to about the middle of the course. Because in the first lessons, I don't want to frighten you away, but there comes a point in time when we do have to learn the rules of the game, because if you can't learn or can't know the rules of the game, you can't play it. It'd be like trying to play football, and you don't know what a pass is, and you don't know what offsides means, and you don't know what penalties are, and you don't know whether you can lateral forward or backward. If you don't know the rules of the game, then obviously you're at a tremendous disadvantage. And people go into the courtrooms not knowing the rules, and this is why citizens can never win in the courtroom, because they bumble and stumble and they sit there and, well, now what do I do next? And so this professional lawyer, he sits there making all of the timely objections. He makes all of the clever remarks. Every time you open your mouth, he says, "Objection, Your Honor, these are gratuitous comments," or "Objection, Your Honor, these are irrelevant and immaterial comments," or "The witness is off point," or whatever other technical move may be made. And I know that you've watched Perry Mason and you've seen the skill and the clever arguments that Perry and the clever questions that Perry would ask. Now, it isn't necessary for you to be clever necessarily. It just helps a whole lot. I mean, you can go into the courtroom like this fella that you saw the brief from, Del Bowman. You don't have to be eloquent of speech. You just have to be able to go in there and have a story to tell and tell it. But you know, if you don't get the story told at the right time in the scenario, or if you don't get your emotions put in at the right time, or if you fail to object timely, or if you fail to demand a right, you've waived the right and you can never recover. You've waived the objection and you can never recover. So, as I say, this is an extremely dull lesson, so you'll have to bear with me as I tell you some funny and humorous stories of some of the bloopers that I've made when I went into the courtroom. And from that, let's see if you can avoid the mistakes and the foolishness that I went through, so that when you go in, you can look more like Perry Mason and less like Little Abner. In this lesson, you have a book called The Trial Judge's Manual. Would you zero in on this one for me, Ted? And let's show everyone what we're looking at. The Trial Judge's Manual. Okay, there's one. Now pull out the second book that you've got, which is called the Idaho Criminal Rules. And that I don't know the color of, but you have a little book there. I'll hold this one up. And you notice that I use these binders. This is called the Idaho Criminal Rules. You do this even if you're in Texas. You pull out these two books, because that's the subject matter of today's lesson. Now, there's another book here that I happen to have, which I don't want you to buy. And this is called the Idaho Rules of Civil Procedure. Can we zero in on that one there? Here we go. Idaho Rules of Civil Procedure. Let me repeat. Do not buy this book. And we're not sending you a copy of this book. I'm going to tell you why right off the bat. I paid $45 for this turkey, and it isn't worth 35 cents. Because remember, first of all, the only thing that you're learning to do here is defend yourself criminally. You may have a lawsuit from time to time that's instigated against you, or you may want to sue someone. But I certainly don't think that you're in a position to sue anybody until you're first able to handle a speeding ticket or a parking ticket or handle a criminal matter of a lesser degree. So our entire course is designed then around the criminal procedures, the 2-2-2 rule, right? All right. Let me tell you a little story about this book. I thought I needed the Idaho Rules of Procedure, and so, I don't know, someone told me that you buy these books, and so I went ahead and bought this book. And this book is out of date every year. And since it's out of date every year, it has a pocket supplement to it. Now, I've spent $45 for a book. I don't know where to get the updated pocket supplements. and I've had it for about 3 years, and every time I look something up in it, I have to go up to the law library to make sure that it's the latest dope. So when you're talking about the rules of civil procedure, and if you'll now just follow along with me, take out your course outline, take a look here where it's marked Lesson 12, where it says State Code of Criminal Procedures, and let's see just how many books are there. Remember what I've told you in the past. We want to isolate the problem. We want to see what is it that we have in the way of a problem, then how do we solve that problem. We have criminal rules, civil rules, misdemeanor rules, the court rules, which will be the local court rules in your district, whatever they may be, and then the trial judge's manual. All right, so we've got what? 1, 2, 3, 4, 5 items in the way of rules. Now, there may be more, but there are no other rules or rule books, to my knowledge, in the United States in our courtrooms. Now remember, we're not going into insurance law. We're not talking about any admiralty jurisdictions. We're not talking about all of these other branches of law. We're talking about criminal law and how these 5 books are going to affect you when you go into that courtroom to argue this speeding ticket. So if you have a speeding ticket, the first thing that you have to have then in the way of rules is going to be the Idaho criminal rules. Now, if you're in Illinois, then you need the Illinois criminal rules. So pull out your book on the subject here of the criminal rules and just thumb through it. And I think that as you thumb through it, you'll come to Rule 54. Here's Rule 55, Rule 57. I think I said there were 54 rules in here not too long ago. Looks like there's a total of 59 rules. There's a Rule 58, which is reserved. Here's a rule that hasn't even been written yet. All right? Now let's flip up to the front of the book and let's take a look, starting at the beginning, at Rule number 1. Every state is going to have a Rule number 1. Remember now, or you should remember at this point in time that we're all functional illiterates. Out of the 500,000 words in the English language, we only know about 10,000, or about 2% of the total words that are available to us. Remember, I've said that anyone who knows as little as 2% of a particular subject has got to be an illiterate. It's got to be dysfunctional in that topic. A fellow came in yesterday, and he's a copy machine repairman. And I said to him, how much knowledge, percentage-wise, do you think you'd need to repair a copy machine? He said, well, looks like I need about 90 or 95%, and what I don't know, it can't be very much, so that I can call the office and ask. So to fix a copy machine, the copy machine repairman says you need to know about 90% at least of the information, or have that much knowledge about copy machines or the particular machine in order to consider yourself competent to repair copy machines. So the first thing I'm going to say is that we're all incompetent then. At least I know I'm incompetent when it comes to reading, knowing, and understanding the rules. So let's try this on for a personal rule. Let's assume that every word that we read in the rules is a word that we do not understand, and if necessary, we're going to ask the judge for a judicial clarification of the meaning of that word in that rule. Now, of course, you should have your Black's Law Dictionary, and you should go through here and look at the word like scope, courts, and exceptions. I'm on page 418. It's up in the upper right-hand corner, and it says 418 up there. And you've got Rule 1. Follow along. These rules apply to all criminal proceedings in the district courts and the magistrates' divisions thereof of the state of Idaho, with the following exceptions. Oh, wait a minute. Underline the words with the following exceptions. And I'm going to show you something here that's probably going to be more important to you than the definitions of the words. What isn't said is oftentimes more eloquent than what is said. And when you find the word exception, that means we're talking about these are the rules except but. And it just could be that you're one of those except buts. and you're going to go into the courtroom being prosecuted by an information, but you're one of the except buts that can only be prosecuted by a grand jury indictment. And unless you object timely, and unless you demand your right to the grand jury pursuant to the Constitution or the statutes or the rules, well, then you're going to waive the right, and when you're finally convicted on the information and sent to jail, you will not have an appealable issue. All right? So watch this. As we look down, when we're talking about extradition of fugitives for justice, forfeiture of property for violation of a statute of the state of Idaho, see, whenever they take your car from you, you're not dealing then with the criminal rules. It's some other rule, but it isn't these rules. Collection of fines and penalties. Oh, do they ever collect fines and penalties under criminal rules? Juveniles under the Youth Rehabilitation Act, juveniles under the Child Protective Act. In this state, that's Title 16. Habeas corpus. There's no rule in here about habeas corpus. Uniform post-conviction proceedings except as provided in Rule 57. So what we're reading here then is that there's a Rule 57 for post-conviction proceedings. But there must be some other post-conviction proceedings somewhere else, because it says here, except as provided in Rule 57. So there's an exception, and there's got to be something else. Coroner and coroner's inquests and proceedings in quo warranto. Well, now, there's a word. I've heard it, quo warranto. I don't know what that is. Never used quo warranto. Been in the courtroom many, many times. I've won many, many cases. But I've never used quo warranto. So if I wanted to use that, or if somebody brought that subject up, if I saw that word on an information or a complaint, point of order, Your Honor, here's a word that I don't understand. It's called quo warranto. I believe it's in order for us to take a 5-minute recess while I investigate this word so that I can understand the proceedings being held against me. If the judge says, I don't care whether you understand it or not, we're going to move forward anyway. That could be a major federal question. You could be now railroaded through to conviction not knowing the charges against you or not knowing a very important fact. When you don't understand a word, it's important to object to it. If you don't understand the proceedings, object to it. Now, when you make these objections, they're apt to say to you, okay, we're going to appoint counsel. It's obvious that you're incompetent, and therefore we're going to appoint a lawyer. Wait a minute, you can't do that. Remember from our book on legal quotations, you have to have the right to secure counsel and counsel of your choice. And it could be conceivably even worse if you had to accept counsel beholden to your adversary. In a case called Zerps versus California, that issue's already settled. You cannot tell a man that he can't defend himself. And so you need to make that objection timely. So let's take a look then at what we see here when we're looking at Rule 1. We see here that these rules apply to all criminal proceedings. That's like reading in your federal Constitution, all free persons in the district courts and the magistrates' divisions thereof, with these exceptions. So you've got free persons then bound to service for a term of years. So there's two branches here. Always look for the word except. And look for words that say may versus shall. You know, when a statute says, or a document says, a warrant may be issued for your arrest, that's a lot different than saying a warrant shall be issued for your arrest. One's a command and the other is a maybe. All right. So now we know the exceptions, and we'll flip over here in Rule 2. Purpose and construction. Title, district court rules. Let's see what this says. Let's see if it makes sense to us. The purpose and construction, then. These rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and elimination of unjustifiable expense and delay. All right, so there's three things then, right? Three objectives. They shall be construed to secure simplicity, that's so that you can understand the proceedings, and fairness in administration, and the elimination of unjustifiable expense and delay. Well, if it's justifiable expense and delay, then that's all right, isn't it? So let's suppose that the judge comes down on you and says, we're not going to permit this unjustifiable delay. Well, Your Honor, let me object. This court is attempting to put me in prison and take my life, liberty, or property, and I demand due process of law. I don't believe that it's an unjustifiable expense or an unjustifiable delay. Any case that's important enough for my government to prosecute is important enough for me to defend. And I'm here defending my rights, and where rights are involved, there can be no rulemaking or legislation that would abrogate them. That's Miranda. That's Miranda, page 491. In other words, do you see your rebuttal here? You cannot go into the court and obstruct and delay it. And there's a lot of kooks and quacks that run around, and their purpose is to obstruct and delay. If you're going to obstruct and delay, then you need to be clever about it, don't you? You cannot allow them to know that you're obstructing and delaying. It's like picking a jury. You know, it may take all day to pick a jury. And you may be asking questions designed to bump jurors that you may like, just for the purpose of taking a full day to pick the jury to run the cost from $1,500 to $3,000. Okay? Well, if you're doing that, don't ever make that admission or confession. Don't ever let the court know that that's what your purpose and goal is. Your Honor, these jurors over here are very concerned, are of a great concern to me, because I notice in the jury selection that 9 of them are government employees or the wives of government employees. And I feel that these witnesses, or these jurors rather, need a great amount of scrutiny by the defense to determine whether they can be totally fair and objective to a person who doesn't work for the government and who is in fact challenging government power and authority in its constitutionality. See the way you make that argument? Then you go on to bump jurors by asking questions. A key question is an example. We have a student here that was in court not long ago, and he bumped 4 jurors in a row. And it was really disconcerting to the court. They thought, well, he's obstructing and delaying. There's only 16 jurors starting. They lost 2 somewhere along the way going in, and so here's 16 jurors, and he bumps 4 of them right out of hand by asking them the question, you know that I've been arrested. Doesn't that tell you that I must have done something? And they said, well, yes, you must have done something. Well, there's the statement then that they're already prejudiced. They've already made up their mind. They have a conclusion. It's in their mind, anybody who's been arrested must have done something. You might not have done what you're charged with, but you did something. And so, you see how key that question was? I've been arrested. Doesn't that tell you I must have done something? The juror has to answer the question, no, I don't know what you've done. And just because you've been arrested doesn't tell me anything. You see what that juror should have answered? And yet, this particular student's a very crafty, and he's a very careful and deliberate individual. Now, remember, I've said this time and again, and I'm going to say it again. And I'll say it again and again. The way that we get to our courts and the way we get to these prosecutors and their lawlessness and their malicious prosecutions and their high-handed deprivation of our rights is through the pocketbook. When those trials cost $1,500, when that speeding ticket takes a full day to try that case, let me tell you, friends, that's a message that is more eloquent than anything that I could say or that probably you could say. When they get to the end of the day and the jury comes in with a guilty verdict and it cost $1,500, and there they have the speeding ticket and it's worth $40 to you, or worth $40 to them, I should say. All of a sudden now they've spent $1,460 to collect $40, and that isn't lost on them. And that's your goal. Make it hurt, because that's what they're doing to us. They try to make it hurt by dragging us through these court procedures and through these court processes. They charge us with pretended and feigned crimes, and then drag us into court day after day after day. It isn't uncommon in a traffic ticket to be in court 5 or 6 times, to lose 5 or 6 days' pay. All right? So if they're going to make it hurt you, and remember, they never make that admission in confession, you'll never hear a judge or a prosecutor ever say, yeah, that's right, dummy, the next time you'll just pay your $40 and shut up. So when you get into the courtroom, you keep your mouth shut. Don't you ever tell them that the only reason we're here is to cost you $1,500. I know how the jury's coming in. See how that goes? Works 2 ways. Hypocrisy is a wonderful tool. It can work for you, it can work against you. And any hypocrite that can use hypocrisy against me doesn't know how well I can play sandbox. Because I can play sandbox like anybody else. Now, what I'm giving you here is a reading lesson. Do you know that you're an illiterate? Yeah, that's right. Unfortunately, we're all illiterate. And then when we read a sentence or we read a clause, we think that it means something other than what it says in law. Remember this and don't ever forget it. If it doesn't say you have to do it, then don't make the assumption that my common sense tells me that I have to do it. And if it says don't do it, it's got to be specific. It's got to say you shall. Now there is a sign. I'm going to digress here for a moment and tell you this little story, and I'll show you how this works, because this is crucial. There is a sign at the scales down at Bliss, Idaho, and the scale says, all trucks exit next left, or next right, I guess it was. And so I went into court. Now, of course, my truck didn't exit. My truck ran the scale. Got into court, and it was before I'd gotten my reading lesson, and the jury had come back with a guilty verdict, and this is this same judge who had put his arm around my shoulder, and he said, I wish I had this case. I'd win it in 5 minutes. And we went on to have the jury come back guilty, and then we had to appeal. It took me 11 months to win that one. I could have won it in 5 minutes, and instead I didn't know what I was doing. It took me 11 months to win it. We went back into the judge's chambers, and here's the long and short of it. The statute said, all trucks loaded with, and I mean it was a whole page, like this, a whole page of all trucks loaded with iron and steel and loaded with hay and milk and sugar beets, and just went on down the line, shall enter and clear the ports of entry. Do you know what it didn't say? It didn't say unloaded trucks. There was the loophole in the statute. There was no evidence that my truck was or was not loaded. So if my truck was loaded with any of the things that were listed in the statute, I had to enter, clear, and pay duties in the port of entry. But if the truck was empty, it was excluded. So the first thing you have to know and understand is that when you're reading something, if it doesn't say empty trucks shall exit next right, well then empty trucks are excluded. Now I know that common sense tells us when the sign says all trucks next right or all trucks exit next right, you know, it means empty trucks. That's what the sign says, but the sign isn't the law. The statute is the law. So when you're reading these rules, it's, does the rule say you shall or shall not do this? Does it say you may or can do this? All right, now let's go on here a little bit. In this Rule 2, it says, this is 2C, District Court Rules. No district court or magistrate's division of the state shall make rules of procedure except as expressly authorized by these rules. All right? When you catch a judge who's doing something that's outside the scope of these rules, nail him on it. I object, Your Honor. Would you show me the rule that allows you to do this? It's called point of order. And you're going through, and this judge is going to make some kind of a ruling. Let's just pick a ruling out. You may be in a motion hearing. I know over here at Rule 5, here's a keen one. I think it's Rule 5.2. Yes, let's look at Rule 5.2 just for fun. It's on page 426. Now let's see whether or not the judge is going to obey this rule. Where it says transcript of hearings, here's one that the judges in Idaho just violate time after time after time. These lawless judges sometimes, I shouldn't say they're lawless. Maybe they're ignorant and don't know the rule, or maybe they just don't want to be bothered with it. In any event, I'll take advantage of it because it's a right that I have. Now, we know under Rule 2 it says there are no other rules other than these rules. So this is the law of the courtroom. When the court is in session, these are the rules of the game. So let's see what it says about transcripts of hearings, okay? It says copies for parties. Well, what is a party? Is the defendant a party? Okay, so I'm a party to this action. And it says the transcript of proceedings on timely motion to the district court. Okay? You can't just walk in and say, I want transcripts. You have to do it on timely motion. And isn't that what it says? So don't get mad at the court now if you walk in and say, hey, I didn't get a transcript of the arraignment like I told you I wanted. It says on timely motion to the district court by either the prosecuting attorney or the defendant or his attorney. And in our case, we're not going to have our attorney, so it's going to be done by us. The court shall order a typewritten transcript, underline the word typewritten transcript, and copies of exhibits or affidavits to be made for such party of any of the following records. Okay? So we're entitled to a typewritten transcript under this rule of the following records. Now let's see what records we have a right to a typewritten transcript to. The record of any probable cause hearing for the issuance of a complaint, a warrant for arrest, or a search warrant. Try and get one of those in the state of Idaho, friend. Good luck, because I've been doing this for 5 years, and I've never, to my knowledge, ever put a case together that I haven't demanded the record of the probable cause hearing. If you'll pay them $3.50, you can get the tape, but you won't get the typewritten transcript. Number 2, the record of any preliminary hearing, and B, listening to a recording. So you're entitled to a recording. In the event that a record was made by a recording device upon request by any party, the court shall order. Notice, the court shall order, not may, can. If all the facts are in, and my theory is, says they shall order that the recorded tape or other recorded means be replayed for the benefit of counsel, and the court may fix the time and place and set the conditions under which such replay may be afforded. Okay, so you're entitled to listen to that. And in our county, we have a man who takes care of those tapes. But remember, you have to do what to get these people to do this? On timely motion. You can't just walk into the court and say, can I or I want. It's got to be done in writing. It's got to be by motion. Don't know how many pro se's make that mistake. Well, I told them on the record that I wanted it and needed it. Oh, I see. Did you file a motion? Mm-mm. Oh, he didn't file a motion. I think that's probably why you didn't get it. And then, if later on you claim reversible error because you didn't have the typewritten transcript or you didn't get a chance to listen to the recording or the tape, you waived your right because you didn't do it pursuant to the rules. And let me tell you, when this case finally gets to Washington, your adversaries are going to be calling every rule. They're going to say he didn't follow Rule 5.2. He didn't follow Rule 4. He didn't follow Rule 12. That's what they're going to call on you, and they're going to be right, and they're going to shoot you down. So that's why you need to read the rules. Now, you want the typewritten transcript? Here's the way you get it. Let's go on. Number C, filing record with the district court. Whenever a record is transcribed in whole or in part, a copy thereof, duly certified, it shall be filed with the clerk of the district court. Have you ever asked them if there's a copy, typewritten, filed with the district court? Requesting recording in lieu of transcript. Okay, you can get a recording in lieu of the transcript. Should any counsel desire a copy of the record made by a recording device, the provisions concerning written transcript shall be applicable to the furnishing of such copy. But the district court shall determine in its discretion. Now we've got in its discretion whether a recording will be furnished in lieu of a written transcript. All right, so you can demand the written transcript, but the district court can then come along and say, well, wait a minute, that costs too much money, and therefore we're not going to pay for that. And then they'll try to make you pay. Watch that one. Send for our brief on that subject and see if it applies in your state. You know, in a criminal matter, you're not going into the court there suing someone, and there's no reason why a criminal who's defending his life, liberty, and property should have to pay for anything. You think these criminals that murder people and rape, rob, and pillage are out there paying for these trials, paying for their way? No, they want us citizens to do that. You can get due process of law if you're a rapist, but you can't get due process of law if you're one of the tax-paying subjects and servants of the government. So in its discretion whether a recording will be furnished in lieu of a written transcript, any certification of transcripts, all typewritten transcripts shall be duly certified by the appropriate magistrate or his clerk. See how important it is to read the language, read the construction of the sentences, to see whether or not you can get a typewritten transcript. Well, when you're in a court that's making a recording, and you've got this stenographer in there, okay, and she's making this, then there is no recording. And it's impossible for you then to understand what she's saying. You couldn't take her notes and make your own transcript, could you? All right, that being the case, when that type of a recording is made, or that type of a record, you're entitled then to a typewritten transcript. But if you're in the traffic or magistrate's court and they're using a tape recorder, you're not entitled to a transcript in writing then, are you? But you are entitled to the tape. Now, you can argue as to whether or not you want to pay the $3.50. That's the money issue, and it may or may not be relevant, and it may or may not be worth taking your time, effort, and energy to write some motions and argue. But let me tell you, there isn't anything that I won't argue about. If I went into the courtroom and there was a question of who's going to sit at the right or the left table in that courtroom, and they told me to sit at the right table, if I had a rule or a right to sit at the left table, then I would invoke that rule or that right. If for no other reason, let them answer your paper. You know, bureaucrats love lots of paper. And I think that we should do everything in our power to help those bureaucrats. I like to cooperate with my government. They like paper, I like to give them paper. And we give them paper. Now, there's a rule here, and I'm not going to cover every rule because obviously we've only got 3 hours here, and there's a lot of information that I want to cover here in this 3 hours. But I'm going to teach you how to use these rules. Because remember, there's only 5 books. The first thing that I always recommend is that one, just read through them. Just read it like you were going to read a Mickey Spillane novel. When you get to the end of it, you're going to have the information between your ears. Now, the rules are written in a logical sequence of events. In other words, you don't have post-conviction relief as rule number 1, do you? That was rule number 57. And if you'll notice, appeals are rule number 54. All right, so the rules are written in the logical progression or sequence of events, generally, not always, but in the general sequence of events. They begin with the warrant being issued, and they conclude with post-conviction relief. So, you know that you're going to go through an arraignment, and you know you're going through some motion hearings, some exclusionary hearings. You want to exclude evidence under the exclusionary rule, and you got a preliminary hearing, and there's a number of steps and procedures that we need to go through. Okay? So let's take a look here and see what rule we need to be looking at if we're going to go to an arraignment. Let's see whether or not the court is going to obey the rules, because typically these people don't obey the rules very well. Now, that's not all judges. Boy, some judges are very careful, and they'll dot every I and cross every T. But that isn't necessarily true with all of the judges. My experience has been that about 10% of them know the rules and apply them scrupulously and carefully. If a judge is on your side and he likes you, and he believes in what you're trying to do and claiming your rights, and I had this happen not too long ago, he deliberately violated one of the rules, a rule that will guarantee me that the case will be dismissed under the 21-day rule. See, in a felony, you have to be brought to a preliminary hearing within 21 days. Now, no one is ever going to be able to put the finger on him and claim that he did that deliberately to help me. But when the hearing came up on the 25th day, I was surprised. And I didn't write him a letter on the 18th day and remind him that we only had 3 days to go, or else I would move for dismissal. He knows that I want to move the issue into the higher courts, and I want to expose the graft and corruption in our local prosecutor's office, and I think he just said, well, let's make sure, just in case old Gordon fouls up his case and he gets convicted, that instead of him going to the penitentiary, he can always use that as an appealable issue, a winning appealable issue. So I appreciate that judge giving me that winning issue for me to appeal. And meanwhile, I've made my objection timely. I said, Judge, you need to dismiss this. And he said, no, I don't. And he didn't. And so I've always got that. I'll argue that clear to the U.S. Supreme Court, that they didn't obey the rules. So, you go through and you write motions then pursuant to all of the rules, don't you? Rule 5, Rule 2, Rule 4. And as you write the rule demanding your rights pursuant to that rule, when the judge fouls up, there's an appealable issue. It's kind of like going out on the football field and the other guy is constantly offside. And every time he's offside, you say, hey, referee, did you see that one offside? And he doesn't call it, and he doesn't call it, and he doesn't call it. Okay? Finally, there comes a point in time when we're either going to throw that official out of the game, or we're going to have some kind of a big rhubarb as to whether or not that team really won or not. All right? And that's the way it works in the courts. You want as many reversible errors as you can get, and the only reason that I only file an appeal with 30 issues of reversible error is because I couldn't write up 60 or 120 or 240. I'd write up 240 if there were that many. So you need to be alert to each and every one of these rules. And every time that there's a man offside, every time that they jump the gun, every time that the pass is incomplete, call them on it. Every time. And you can only do that by reading through the rules and knowing how they're coming down. So you need to write a motion then under Rule 5.2 and demand a written transcript or the tape or an opportunity to go listen to the tape. And if they won't let you do that, they'll say, when you get to trial, the judge will say, are you ready to move forward, Mr. Gordon? Absolutely not, Your Honor. It was necessary and imperative that the defense have this tape of the preliminary hearing or a typewritten transcript. I've motioned it up timely, Your Honor, under Rule 16 and under Rule 5.2, and the prosecutor has refused to make it available to me. And I absolutely am not prepared to go forward. All right, one of two things has to happen. Dismissal for failure to move forward, or they have to move forward against you because it's the day of trial, and when they move forward against you, reversible error. And that's called rushing the defendant to judgment. That's a no-no. You cannot be compelled against your will and over your objection to move forward when you're not prepared or ready. But you have to have a reason for not being ready to move forward. And if you're not ready because of an error on their part, then that's not harmless error. That's an error that prejudices your rights. It prejudices your ability to move forward and defend yourself. See how important that rule becomes then in your favor? Use it every time. Let's just take a quick look at Rule 4. That's on page 421. Let's read through there. Let me show you a couple of three real nifty maneuvers or procedures that have to be scrupulously applied to your case each and every time. And remember, this Rule 4 is only one out of hundreds. Because you've got all of these rules, you've got all of these rules, you've got all of these rules. There's about 800 rules for these people to obey and apply in your case. And they only have to apply them now if you make them apply the rules. I know you're going to sit there and say, well, that's not fair. I don't even know what they are. Now do you see why citizens are routinely convicted? If you don't call the rule and bring it to the judges, who is also the referee's attention, then you've waived your right. Now, you can say that that isn't right and that it's bad, wicked, terrible, and awful and ought not to be that way, and you can sit there and argue until the millennium. Won't do you a bit of good. Won't help you a bit. But if you object when the rule is being violated, either do one of two things. Make them obey the rules. Make them obey the law. Walk into that courtroom and don't be afraid and timid. Your Honor, I think it's time that this court obeyed the law. I know that that's new and unique and probably hasn't been done in this courtroom for many years. But I'd like to, with all due respect, Your Honor, bring your attention to Rule 4. All right, going on. Warrant, summons, and determination of probable cause. All right, so let's read through and see what it is that we're trying to do. We're trying to get a warrant and a summons. Well, were you arrested or were you summoned? Was there a warrant for your arrest? What if the policeman arrested you and you didn't have a warrant? Did you ever think about asking for the warrant or the return on the warrant? And what magistrate or judge signed the warrant? If they didn't, then it's false arrest and false imprisonment, isn't it? And do these things ever happen? About many, many times. I won't say what percentage because I really don't know, but I know that in this county they're a whole lot more careful about the rules than they were a year or two ago when we started doing this, going into the courtroom and demanding that our public officials obey the law. And after all, why should they obey the rules and obey the law unless somebody's going to make them do it?